Now, my understanding is the non-union employees who've been doing the crane work at the Leatherman Terminal have always been non-union. In fact, they work for the state of South Carolina, where monopoly bargaining is prohibited by law. So if the ILA never had these jobs, how could it possibly be work preservation?
Well,
How can you preserve a job you never had? Thank you for joining us at the Norma Zindahl studio. My name is Bill Messenger. I'm the legal director at the National Right to Work Legal Defense Foundation. And today I'll be talking to Glenn Taubman about a distressing situation about a union trying to take the jobs of non-union state employees at the Leatherman Terminal at the Port of Charleston in South Carolina. Glenn, welcome.
thank you.
And so just some background information. What exactly is the Leatherman Terminal and who currently works there?
Right. So the Leatherman Terminal is part of an expansion of the Charleston ports. The state of South Carolina spent $1 billion to expand the ports and provide job opportunities because, being a right-to-work state, the economy was booming in South Carolina.
And so the employees who currently work there, who exactly are they? State employees? Are they private sector employees? Are they union? Are they non-union?
Right. So in the South Carolina port, most of these jobs, some 2,000, are private sector workers. But the state of South Carolina, which owns and operates these huge cranes that lift the cargo, they have 270 state employees, non-union state employees, that operate only these lift cranes. The rest of the jobs are private sector jobs under the Longshoremen's Union.
So these crane operators and lift operators, these 270 state employees, they're non-union. But my understanding is that a union, the International Longshoremen Association, or the ILA, is trying to take the jobs of those 270 state employees. Can you tell me exactly what's happening with that?
Sure. So this is the scheme of the ILA, to take every one of these jobs. They have 2,000 and they want these 270 state employee jobs. So when Leatherman opened and ships started coming in there to unload, the ILA sued the ship owners in federal court in New Jersey, basically saying this was a violation of their collective bargaining agreements. They claimed that under their agreements, every single port job had to be a unionized job. And as a result of that, they were suing in New Jersey federal court all of these ship owners when they came into port. And the argument was, even though these state employees were only doing this specific crane and lift operation, no ship could dock at this port and unload without every job being an ILA job. So they were using this pressure to prevent the Leatherman Terminal from being used.
It sounds to me like a secondary boycott. For those watching who are unfamiliar with what a secondary boycott is, this is when a union tries to get one company, a group of companies, to pressure another company to unionize. So in this case, it seems like the International Longshoremen Association is having the shipping companies try to force the Leatherman Terminal to give the jobs of these non-union employees over to the union. This seems like a classic secondary boycott, which the National Labor Relations Act has prohibited since at least 1947. And so did the Port Authority or anyone else file charges or try to do something about this secondary boycott activity?
Yes. Well, in fact, it is, in our view and in the view of many, a secondary boycott that's illegal. So the South Carolina Ports Authority filed unfair labor practice charges against the Longshoremen's Union with the National Labor Relations Board. And the first level of the National Labor Relations Board, the administrative law judge, ruled in favor of the South Carolina Ports Authority and said, yes, this is an illegal secondary boycott. So far, so good. The union then appealed, and the Biden NLRB, by a 2-to-1 vote, overturned their own administrative law judge and said, no, this is what we call work preservation. And because it's work preservation, We're going to say that it's not an illegal secondary boycott and it's all okay.
Now, my understanding is the non-union employees who've been doing the crane work at the Leatherman Terminal have always been non-union. In fact, they work for the state of South Carolina, where monopoly bargaining is prohibited by law. So if the ILA never had these jobs, how could it possibly be work preservation?
Well,
how can you preserve a job you never had?
Right. Well, that's the great question, right? How can you have work preservation, an established doctrine under the law, when you're not preserving the jobs? Because the union never had these crane lift jobs. Since time immemorial, they've been state non-union employees. And their argument is, well, somewhere along the East Coast from Maine to Texas, some people in the union worked crane and lift jobs. So that means these jobs should also be preserved. So this is sort of the legal nub of the dispute. But when the case was in the National Labor Relations Board, one of the board members wrote a very strong dissent explaining why that if you're preserving jobs, it had to be preserved in that locality, not because somebody somewhere between Maine and Texas also had a crane and lift job.
So the Biden NLRB, perhaps unexpectedly, refuses to enforce the law to stop a union from seizing these non-union jobs in violation of the NLRA's secondary boycott provisions. What sort of happened next in the case? Was there an appeal from the NLRB, or what's happened since that decision?
Yes, so the Ports Authority appealed to the United States Court of Appeals, which is where appeals go in NLRB cases. And surprisingly, by a 2-to-1 vote, the Court of Appeals affirmed the NLRB decision and bought their rationale that work preservation meant any job between Maine and Texas. As long as anybody did it anywhere, that was enough to, quote, preserve jobs, notwithstanding the fact that South Carolina, being a right-to-work state, there was no collective bargaining for state employees. No private sector employee had ever done the crane and lift work. And in fact, the state owned the cranes and the lifts. So the Court of Appeals affirmed the NLRB ruling, and that's where the case stands now.
So sort of just moving away from the legality, the legal issues, turning to like the practical effect. If this NLRB ruling stands, what does that mean for the 270 non-union state employees at the Leatherman Terminal if nothing happens to it?
Right. Well, that's the bad part of all of this, because they will have to be fired, because the state cannot afford to have $1 billion terminal sit idle. And so if all of these rulings are affirmed, the non-union South Carolina workers will have to be fired. It's as simple as that. What happens to them? Nobody knows. Will they be able to reapply for these jobs when the jobs are being run by a private sector company under the thumb of the ILA? Nobody knows. And they probably won't be hired because they'll be at the bottom of the seniority list. So they're going to be out of luck if this scheme is allowed to prevail.
Yep. And other employees will also be out of luck if this scheme prevails, not just with respect to the ILA, but the legal precedent. The idea that work preservation here counts for an entire seaboard worth of work. Right. And so what are some of the implications of the Biden NLRB's refusal to enforce the secondary boycott laws and like expanding work preservation to basically count work that unions just want, even if they never had it?
Right. Well, the ramifications of this is unions will have yet again a new potent organizing tool to go and grab work that they never had. And they can just go use this secondary pressure to boycott companies, to force company A, to force company B to turn over the work to the union. So it's just a potent organizing tool that the Biden NLRB has handed its friends. And this can play out all over the country. It's not just limited to the port of Charleston.
It's appalling. But the case isn't over yet, correct?
Right.
And so what's sort of the last sort of stop on this case potentially?
Right. So Thankfully, the Ports Authority filed a petition for certiorari for review in the Supreme Court. And the foundation, as we filed a brief below in the U.S. Court of Appeals, will be filing a brief in the Supreme Court asking that they take into account the fate of the 270 non-union workers who have chosen to work non-union, who don't want to be under the thumb of the ILA, and we will be arguing on behalf of those employees to make the point that they are the ones that will suffer from this scheme. 270 non-union workers, state employees, and their families will suffer if this scheme is upheld. So we are hopeful that the Supreme Court will stop this and will review the case. And there are so many jobs at stake here that we are hopeful that they'll take it.
Yes. And our understanding is, looking at the Supreme Court calendar, the Supreme Court will probably decide in January of 2024 whether or not to take this case. Of course, if they do, the foundation will once again submit a brief arguing on behalf of the individual employees whose jobs will be seized as a result of these secondary boycott provisions, or secondary boycott the ILA is performing, and the Biden administration and NLRB refuses to stop. For more information about this case and to watch for future developments, you could go to the National Right to Work Foundation's website, www.nrtw.org. And of course, if you find yourself in a similar situation, probably not maybe on a dock, but if you're aware, if you're working at a company, if you're a non-union employee, and you hear that a union is trying to get one company to force your employer to take your job away and give it to the union, you can also contact the National Right to Work Foundation for potentially legal assistance with your problem. Thank you very much.